But we've had a couple of scenarios come up with PICRA deadlines, PICA deadlines. And so Thomasina and I thought that it would be good to review, especially for if you've been in the business maybe just a couple of years. Some things are complicated in the PICA. It's almost like I would recommend you take a blank copy and just put little side notes, highlight deadlines when you're putting an offer together, maybe even keep a list of what the deadlines are, because honestly, it is very confusing. So these scenarios are based on things that have happened. You've got a purchase agreement for a property, 2313 Shorehaven Drive, Unit 203, a condo not too far from here. And it's ratified July 1st, and the blank in paragraph 2A of the PICA is 7 days for your home inspection contingency. So your buyers have their inspection, they're on the fence. And so you've sent them both a proposed PICRA and a release and termination for them to consider. And then on the night of July 8th, after you've already gone to bed at 10:30, you get, I guess, the dot loop notification. I'm not sure what it looks like on your end, that the buyers have signed the release and termination, not the PICRA. So you don't see it until the next day. So you get up in the morning, you talk with a buyer to confirm it, and about noon, 12:30ish, you submit that release and termination on July 9th to the listing agent through dot loop. So here are a couple of true false scenarios. The first one is it true or false? And I'd like this to be answered by a newer agent. Maybe if you've been in the business, the older agents, I know you know. So maybe on this first question, some newer folks, the release and termination were timely submitted because July 4th, a federal holiday, is not counted in the calculation of days. Does anyone want to say that that's true? Or does anyone want to say that it's false?
True.
See if anybody's brave.
This is Miriam.
Yes, ma'am.
I would say that is true only because a holiday isn't considered a business day. Is that correct?
All right, now I would like someone to take the other position. We're going to act like we're back in school. Does anyone want to say the other position? Okay,
I say false because Sunday's not considered a holiday either, but it still counts within the time frame.
Does anybody know what paragraph of the purchase agreement would answer this dispute between the two of you all as to whether or not that July 4th counts? Does anybody know where you'd find that in the contract?
I've never seen it in the contract.
Okay, you probably don't have a purchase agreement in front of you, but if you take a look at paragraph, Holly has one.
Yeah, I was just going to say it specifies at the end of the contract under, I think it's miscellaneous, where it identifies the difference between a business day and a regular day.
Yes, you're right. It's paragraph 24, miscellaneous. Oops, upside down. Anyway, it says that the term day shall be deemed to mean any day of the week, Monday through Sunday, both inclusive, regardless of legal or religious holiday. So you count Sundays, you count 4th of July, Christmas, everything, which can be a little ruthless sometimes in how that plays out. So maybe when you're filling in a number of days in the blank, consider whether or not there might be a holiday or some day that your client wouldn't be able to necessarily get you a response. So we know that we do count July 4th, and we would also, like you said, Stacy, count Sunday as well. So we do have to count that as a day. So what is the deadline? So somebody just count the days for me. And if you got a ratification date of July 1st, what's the date by which your client needed to submit a PICRA or a release and termination? Can someone, a newer agent, quickly calculate and tell me the number of the date? Or anybody?
July 8th.
Okay, Christine, I agree with you. Does anyone disagree that July 8th is the date? Yeah, it's good because if you also look at paragraph 24, it says that you start counting at midnight. So you ratify on July 1, And so you count 2, 3, 4, 5, 6, 7, and then 8 would be your deadline, right? Thomasina, I'm not wrong about that, am I? Or Lucy?
No, you are correct.
Okay,
No,
so.
You're good. I'm a little sad at how long it took somebody to come up with an answer, though.
I think they're just shy. They're not one. So.
We weren't unmuted here. We had people answering here. We weren't unmuted though.
Okay.
Okay.
I'm also upset that the other 27 people did not.
I'm
answer.
sorry. I tried to type it in.
Good job. Okay. So we're not doing business days. We are doing calendar days, and it would be July 8th. So good job, you all, on that. So the next question is, okay, so your buyer signed it on July 8th, and you see there's a timestamp in the signature block. Does that make it timely? The release and termination, does that make it timely? Who wants to say true? Anybody who's maybe a newer agent want to say true or false to that?
I say false. It was not submitted in a timely fashion.
Or the prize winner, that's the answer, because in the PICA, it says that the release and termination or the PICRA has to be delivered within that 7-day period. So that's right, Julia, you're exactly right. So the item C under there, and that's what I think we've already all answered that. The release and termination was not timely submitted, and the buyer is bound to the purchase agreement at this point. So the next step is, and this is, if you're the mentor or the manager for this person, the selling agent in this scenario, what advice, direction can you offer them? What's another automatic out that you might have on this property that you could consider? Look at the property address as a hint.
The condo docs?
Yes, ma'am. Yeah, if the seller hasn't delivered those condo docs, or it's been less than 3 days, then you would quickly change your release and termination to say that the reason is condo docs. So I agree with both of you. That was excellent. I can't think of another unless somebody else can. Another automatic out. So if there's not an automatic out, let's talk about strategy. And I think this is where
You're trying to say if they buy a car or furniture or.
well, okay, so they do something that makes them not qualify for the loan. Is that okay under the terms of the contract? So they pre-qualified, and then they go out and they buy a car, or they don't make their monthly payment.
It could be considered default, but you would have to prove that it's default and they did it on purpose.
Yeah, and the paragraph that Jordan's talking about is, I think it's 7. I don't have a full purchase agreement in front of me where it talks about the representations. Maybe it's paragraph 6. That the seller is relying on the financial information, and that the buyer has to, in good faith, pursue diligently the loan. So if they do something intentionally, it would be a default. But as Jordan says, sometimes that's tricky to prove. If you get a denial letter indicating too much debt or something like that, they might discover it if they call the lender and find out that it was something that was done subsequent to the contract. That could be deemed a default. So yeah, good discussion on that one. I might suggest, if the buyer actually has legitimate concerns, it's not just that they absolutely don't want to buy this property anymore. Try to work it out if it's possible, maybe to see if this, because the seller is going to have to put it back on the market. It's going to take time. The next person may ask for the same repairs. So why not go ahead and try to work out a solution? What are some other things that you could do? I guess it's just to try to, if your buyer really doesn't want to buy this, what would you do at that point? Adam?
Ma'am, you could send an addendum. I'm sorry. You could send an addendum asking for more money off and get them to want to walk away before you walk away, or I'm sure you've heard of that.
Go ahead. You can say.
Stop making payments to the credit
Did I say that
cards.
clearly, ma'am?
You're talking about, say that again, Adam, I'm sorry.
Yes, ma'am. You could send them an addendum asking for more money off than they would probably want to reduce the price even more. And that would make them want to walk away first.
You could do that, but I think really at that point, the seller is kind of in the driver's seat because you've missed your deadline.
Yes, ma'am.
So I don't know. I mean, you can certainly try it.
Yes,
I mean, if they
ma'am.
really
Thank you.
don't want it, I think one thing to do is just offer to let the seller keep the EMD. And then incentive for them there is, and you all who have to input the information, and Rain can correct me if I'm wrong on this, but they're going to have to keep that listing showing as pending, right? If they have not, if they have not let your client off the hook by terminating themselves and or signing the release. So maybe say if it's, $1,000 EMD, maybe you go back and say, why don't you keep 500, we'll get 500. You might get more money in this market. You might do better if you put it back on the market, and you don't want to be held up, going through mediation with us, which is time consuming. So you could try to just let them have some of the buyer's deposit so both parties can go forward.
I have a question.
Listening.
Okay, so like technically if it's just a release, then yeah, they can't switch it from pending and make the listing go active, but the termination agreement, well, it's not really an agreement, it's a unilateral form. So once they send over that termination, that deal contract is done and they could go active while still holding the earnest money deposit hostage. Is that correct?
Well, technically speaking, the buyer did not have the right to terminate when the buyer attempted to terminate the contract. So unless the seller accepts the buyer's termination, which the seller may not want to do, then I don't think that it really is terminated yet. But what you could do is the seller could, quickly send a demand saying, look, you missed the deadline. Your release and termination is not accepted. But if you don't immediately notify us that you're moving forward, we reserve the right to terminate. But then the seller would at that point send their own termination notice. And that way the seller preserves the right to pursue default remedies against the buyer. Because if they just accept the buyer's termination, it will muddy the waters and make it look like the buyer may have had the right to terminate if they then activate the listing using the buyer's termination. That's my opinion about it. I don't know if your managers feel differently, but I think it'd be better if you want to preserve the right to sue the buyer later for default, or you don't want the buyer to come back and try to, make it hard in that situation, then I would submit your own termination that says it's due to the buyer's default and failure to perform. But you have to clarify that they really aren't going to perform now that they know they haven't missed the deadline. Some people may suck it up and just go ahead and buy it if it wasn't too bad of an inspection. Okay. And then of course you might want to involve your manager, especially if you think the buyer's going to find you responsible for having missed the deadline in some way. Just in case the company has exposure, do please talk with your manager. The buyer may need to talk with us or an attorney about advice and potential damages they could face and potential strategies they could use to fend off the seller if there were legal action. Okay, I think the next question, and this is the same scenario with the same contract ratified July 1st, 7-day deadline. Buyer submits the PICRA on July 4th, plenty of time. The seller counters, they enter into negotiations. And then on July 12th, the seller signs and delivers a termination. But then the buyer says, wait a second, and they turn around and accept the seller's last counteroffer. So the buyer is asserting in this scenario that the seller's termination was premature and that the ratified PICRA that they just accepted is binding. Who's right, the buyer or the seller? Was a termination, did the seller have the right to terminate on July 12th?
I don't think so.
Okay, why is that, Shirley?
I think it was the 11th. I'm not sure, but I think.
I think the 12th is correct. They get a grace period between the buyer for day 6 because it's a 5-day negotiation period. And then technically on day 7 is when the seller is allowed to terminate. So that would have been on the 12th.
So when would the 5-day negotiation period end under this contract? If you've got a ratification date of July 1 and the PICRA is submitted on July 4th, when does the 5-day negotiation period end?
9.
Yeah, the
Somebody
ninth,
may have just said it.
the ninth.
The 5-day negotiation period starts on the 5th because they received it on the 4th. So it starts at midnight. So you count 5 days. So 5, 6, 7, 8, and 9. Then you got your grace period day the 10th. Oh, you're right, Shirley, at the 11th.
Okay, I thought so. I was getting confused.
You know what? I can't always math. But yeah, the 11th.
Okay,
I agree with you all. And the reason I wanted you to work through this is just to see how it can be complicated calculating the days. And it's good to make notes to yourself of those dates, you know, when you're putting the, you know, the deadlines together. And also sometimes people could wrongly conclude that you count as you would count from when the PICRA would have been due, which would have been on the 8th. And that's not accurate. You don't count from when it was due, you count from when it was actually submitted.
started, right, okay.
Yeah, okay, y'all are smart, y'all are good.
Doesn't it say in the PICRA, like after the 7th day, any party can release and terminate the
Yes.
agreement? Isn't that the verbiage that's in there? So technically, even though they sent it on the 12th because nothing had been ratified, they could still technically release.
Right, no, they could. I think they are allowed to, the seller is allowed to terminate on the 12th because as we just established, the 5 days from the 4th plus the 1-day grace period ended on the 11th. So by the 12th, the seller can. Okay, same scenario. In this situation, though, the paragraph 14E is checked in the contract, I think it's E, that the buyer desires a property inspection, but the language is added for informational purposes only, as we often see these days. Then in the PICA, in paragraph 2A, it still says the 7 days, but in paragraph 2C, they cross out the heading under 2C, and it writes inspection for buyers informational purposes only. That's added initial, but no other changes are made to the PICA. So prior to the 7-day deadline, the buyer submits a termination and release. The question is, does the buyer have the contractual right to terminate under that scenario, or can the seller say, hey, you know, it was only for information, you don't have the right to terminate? Anybody want to express a position on that?
Yes, they have a right to terminate.
Explain that to all.
It's information purposes only, meaning that, you know, they're not attempting or going to attempt to come back on repairs, but that certainly doesn't waive the contingency where they have a right to release from the contract.
Now, if you wanted it to be that,
That they crossed out on the contract though, under the PICA. Under where it says property inspection, you said they crossed out a section. I'm wondering if that section is the part that allows the release of the contract or not. But in the PICA, it states, or in the PICRA, it states you either deliver request for repairs with a home inspection, a release, and or a termination. So with that being attached to the contract,
yeah, that's right. They would have had to have crossed out a whole lot more than they did in this situation. Here, they did not cross out paragraph 2A that allowed them to submit a release and termination or a PICRA. They only crossed out a heading in a later paragraph. So I agree in this. If you wanted them only to be able to inspect just for knowledge only, like you might have to do with a government property in some cases, or a bank owned in some cases, you would have to cross out a whole lot more. You'd have to cross out 2A and all of the stuff that followed, and just indicate that simply for buyers' information, and that they, you know, to make it clear that they couldn't release, and it really wasn't a contingency. Okay, good
And
job
if-
there.
Can I
Go ahead.
add, if you
Please do.
really want to drive home that we are not going to walk away from this deal at all for any purpose, in the other provisions section, spell it out. Buyer will not ask for a release based on the condition of the home inspection.
Right, Lucy, I agree. I mean, that's risky. And thankfully, I know in the last time we had this crazy spike in the market, we were seeing more of that. I don't think we're seeing as much of that because I think people learned that it just wasn't good for their buyers, to have done that. But yeah, you certainly can do that if it's really really competitive for that particular property. Yeah, I agree. Okay, one last scenario here, the last one at the bottom there. In the same transaction, buyer timely submits a PICRA, but the parties can't agree. So they do enter into a release. You're the listing agent, and now you're in possession of the inspection report. The inspection report says, amongst other things, that there appears to be black mold in the master bedroom closet, wall and ceiling, and also that there are cracks in the driveway and repair is recommended. Do you, as the listing agent, now have to disclose these items in the listing or otherwise? I hate this scenario. Go ahead.
And I personally felt like, because we did have the home inspection that was purchased by the buyer and given to us, that I had to disclose, because this information was no longer, like, it's been disclosed to me, so therefore I had to disclose it as well. In my particular situation, I was fortunate enough to where it wasn't a bad home inspection, so it wasn't like we were needing to conceal anything terrible, so it wasn't like we needed to even feel that way. But in that scenario, I would suggest to my clients, let's get this fixed real quick before we get our next contract, because now you have the opportunity to have it resolved by somebody of your choosing in your financial category, because it's going to pop up on anybody else's home inspection, whether they have a copy of it or not. It will be known. I mean, the cracks in the driveway are obvious, you're going to see those, and I feel like you would see the mold too, but like, by them having the opportunity to go ahead and resolve it, not only could you feel comfortable disclosing it, because you can also disclose, hey, this has been remedied as well. Like, that's just smart in my personal opinion, but legally I think we are legally obligated to disclose, because we can't not disclose, because then we would.
See, I would argue against that, Holly. I would argue against that in that a home inspector is not a licensed mold inspector. So therefore, he's not at liberty. He should not even be saying that it has the appearance of black mold. He can just say there is some sort of microbial growth, but he is not at liberty to say whether or not it is mold or not. So I would argue against it. Not that I think what you're doing, what you would say is the absolute right way to do it, but to take devil's advocate, you could argue against it and say he's not at liberty to say if it's mold or not, so we don't have to disclose it.
Sorry, I had to go quiet the barking dog. Good discussion, and this is borderline, and I appreciate the reasoning that both of you have gone through on this. Yeah, I don't know, Thomasina, if you want to weigh in on it either. Obviously, it's not worth the risk of some sort of license violation if it is something that you think is not open and obvious that wouldn't be discovered. But mold probably wasn't the best example for me to give, since you're right, Jordan. I don't know that the home inspector, was qualified.
Yes, it says even in the CDIF that mold inspection is not part of a typical home inspection.
It's a different certification. Yeah.
Right. Well, anyway, that's
but nonetheless,
yeah.
The
You should
job
take care of it.
Is to point out stuff and recommend for it to be looked at by a licensed professional in that field. So just having it out there in the open, that would be my biggest grief right there. Like, you can't deny that it was called out by a previous home inspector. To determine what it is or not, like that's your job as a seller to go ahead and remedy that situation. But if you don't, if you just try to take that approach where he's not qualified to call that out or whatever, I personally feel like that's just gonna make negotiations in the future that much harder, because now future buyers are gonna think, oh, well, you're hiding this. And I personally would not want to go that route or to represent a seller who has that mindset, because what are you doing, bro?
Yeah, personally, I agree with you 1000%. But just like I said, to play devil's advocate.
Yeah, I
I
think you're
actually
doing
think it was a good scenario, to be honest with you, Susan, because it does happen and it does play both sides for us to talk about. It would really come down to what would the court think, right? If it was really pressed. So what would the judge, do? And we all know that in most likely situations, the judge usually falls on the side of the buyer. But, this is something, again, that you're able to see physically in all aspects of everybody, including the agents, right? It's not just the inspectors. I mean, the agents can see, right? And so what does our license say that we have to do? You got to disclose, because you saw it, right? You can't deny that you saw it. And because we don't know what it is, we still have to disclose it because we saw it. We can't take that away. And that would also fall on the selling agent if they saw it, but proving they saw it would be here or there. We saw it, right? We have to tell the buyers. That's my stance on it, Susan.
Yeah.
Personally, I want another agent to let me know. So I think that honesty is the best policy, and I treat other people how I want to be treated. So if the shoe was on the other foot, I would want that agent to let me know. So I would definitely let them know. And I would try and handle the situation like Holly said. I would talk to the seller and try and get them to fix it before we go through with the contract.
Yep, something for y'all to know though, like that's why I bring it up, to bring up the other side, because that's what I was saying is how a lot of other agents think, and trying to look out for their client's fiduciary, best interest or whatever, to not have it repaired at all, which is understandable to an extent. However, it is important for us to know, like, hey, look, this is how we would handle it, but this is another way that a lot of agents see things.
And that's true. A lot of agents are not the same. So, but black mold, that would not let me sleep at night. If I let somebody go ahead and move in somewhere and they're in there sleeping, I know there's could be black mold. I don't even know if it's black mold or not, but there could be black mold. They could have kids. I just can't do that on my conscience. So
Your license doesn't allow you to not say anything. That's all. Even so, for those of you that may not have such a guilty conscience, your license says that you have got to tell somebody something.
And also,
all not good money. So I mean, that's just that.
If we hide it, it's gonna come out again with the next buyer, and then it's gonna delay things a bit more. So we have to explain to the seller that it's better to do what Holly said.
Right, rectify the situation, take care of the mold, and let them know.
Susan, ma'am, can I ask a question about the mold?
Sure. Oh, I don't know a lot about mold, so go ahead.
If a buyer wants it contingent on a distinct mold inspection, which is obviously distinct from termite and moisture inspection, would you put that on contingencies or other provisions? Because it is it is distinct, obviously, from the main.
On the PICA.
Okay, on the PICA, yes, ma'am. Wonderful.
Right, one of the blanks for, I guess, I can't remember if it's
Other
one of the things that's listed. Yeah, the other inspections. Right, thank you, Jordan.
Yep.
Yeah.
Thank you.
Well, good job, everyone. I really appreciate the thoughtfulness of your answers. And obviously you all are knowledgeable, and you've got good company culture, and it's good to be associated with you. And that's all I have to say, unless Thomasina, you have something else that I missed.
No, I think that's it.
I thought it was awesome. Thank you so much.
Yeah, everybody loves it. As always, on point. Thank you so much, Susan. And we like to, for those of you that aren't here in person, try to get here, because we are having a side conversation as this is going on, and we're kind of talking back and forth with it. And Holly's sitting here in my ear telling me some things back and forth, so
I love
it's-
this debate, I can't help it.
yeah, it's actually good. So when you're here in person, you go a little bit further. I just wanted to make sure there was nothing, if there was something in the chat that we missed, because I was trying to answer all of you with your text messages, as well as listen to Susan, I missed the chat. So if there's something in the chat that we missed, can you type it right now if there's any questions or concerns, and I will read it, because I am watching the chat now.
Looks to me like we got everything on the chat.
Perfect. I just wanted to make sure it said 17 messages, so I just wanted to make sure that we answered that. Thank you, Susan. We really
All right.
appreciate you. And we will talk to you again next month. Don't forget, guys, to send over any questions that you would have. The one thing that I don't think we have, Susan, is the new attorney's email. Can you type in-
Sandra, if you could put your email in the chat. And so when you all send over questions, if you could include Sandra as well as me and Austin, and whichever one of us is able to get back first, we'll do so. All right, so she'll be putting that in, I'm sure.
Okay, and then Nikki has something she'd like to share about the company. There is Sandra's email address, sandral@jwlpc.com. Go ahead, Nikki.
Guys, we had a situation with the seller that wanted to back out of the contract. And it was so good that we had Jones Walker Lake on our side, and we were like, what we did was like, okay, if that's what you want to do, that's fine, but just talk to our attorney. And Jones Walker and Lake was representing the seller, and Austin talked to him on the phone and put him right on track that it's not something that's so easy. He thought he would pay $1,000 or $2,000 and get out of it. But of course that we had passed all of the contingencies, so there was nothing left. And Austin was amazing. He talked to the seller, and we have already closed. So I did want to share that.
That's awesome.
You guys were amazing.
That's awesome. And then Samantha and Una, I want you to share the scenario of the client that didn't want to have, they just want to close the company, but you had them choose an attorney and how that turned out. Either one of you, go ahead and share that story. Samantha, Una. Well, they had a client that they were like, no, we just need to close an attorney anyway. Long story short story long, as Holly says, they ended up needing an attorney, and they were able to talk to Austin and Susan, and they were able to help them through this contract, and it was an investor. And they were so thankful that they had an attorney there available for them. And then Samantha and Una were like, see, that's why you always have an attorney, not just a closing company. And I cannot tell you how many times I've had that story over and over and over again, how people go with a closing company and they think that's good, but then there's no attorney to help them. And it truly is, it's something that isn't good for your client. So you want to do what's in the best interest of your client. And I'm here to tell you right now, having a closing company as opposed to an attorney is not the best interest of your client. I promise you that. Nikki and Munesh, use a closing company. And now I said, listen, I'm telling you now, they see the light, they're like, oh my gosh, we would never ever not have an attorney. I mean, it really, truly is the best. Did somebody want to speak?
Thomasina, it's Sam.
Hey.
I had a client, so a couple months ago, I had a client close in March, and we, on the home inspection, my home inspector was like, hey, there's like very visible, either old or new termite tunnels on the garage. Termite moisture inspection came back. They said everything was inactive and that they didn't, see any new termites, and that the seller has been under treatment for the past year with that client. Fast forward like a month or two after she moves into the house, she hires Pest Out to come out and do another inspection for herself and just get herself in treatment and things like that to make sure it didn't get worse. They told her that the whole garage was infested with termites. And I think it got back to maybe even that the company who did the termite moisture wasn't active, like didn't have an active license. So I referred them right over to Jones Walker and Lake, and they got in touch with, I think, Austin and Susan Walker like right away. And I haven't heard anything otherwise, but so she said everything was like getting handled as far as I know. So it was good that, she already knew them. She already like felt comfortable just going right to them when I told her to. So I definitely would recommend using lawyers for sure.
Okay, thank you all.
That's awesome, yeah. really, really good. Did you use one too?
Well, no, I wanted to backtrack and ask about a scenario. We have somebody in a ratified contract right now, and it was a cash offer. And they asked, yesterday, they asked about getting a loan and were approved for a loan with 50% down at 2.5 interest, and wanted to know our feelings of switching from cash offer after the contract's ratified and accepted.
You always have to have permission to do that, right? It's right in your contract, right? So read the paragraph that talks about it.
Yeah, they have the right to do that.
No, they don't. In the paragraph, it says you have to have permission to change the terms of the contract and the terms of
Saying the seller could turn around and say.
But they don't have the right to do it. That is incorrect.
Don't mean a cash offer could be the reason why their offer was accepted, and that might know the financing could kill the deal,
Yeah.
so they have to have permission.
They have to
from the
have
seller.
permission. There is no feelings about it. They have to have permission.
Yeah, but I would say, but it is possible if the seller.
If the seller.
Anything's possible.
But it's just.
It's
very
gonna delay
dicey.
closing.
No, anything, it's not dicey, it's either the seller will allow it or not. And that's anything, so once the contract is ratified and done, anything that needs to be changed has to be agreed upon by both parties that is stated in the contract, no matter what. So you have got to have that agreed upon by both parties, no matter what it is. And that is one thing, even if you change lenders, and it's the same financing, you have got to have it agreed upon by both parties, even change lenders.
Yeah, so it's not unheard of to go back to the seller and ask, and then if they're against it, they can still give.
Nothing is ever unheard of in a contract with real estate. You have got to ask permission to get everything signed.
Yeah, you as the agent has to present it to the listing agent, the listing agent has to present it to the seller, and then you'll decide, but you have to send over a prequel letter showing that it's already.
The deal, because they could still pay the cash, like the kid seller.
There's not about losing the deal, they would just, the terms would have to be agreed upon and stay the same.
That's not default.
Yeah, that's a contract, that is a contract one-on-one, so make sure that you go to the contracts training to do that, and make sure that you go through this more with them on the
Yeah.
contracts, because that is a simplistic portion of the contract that needs to be gone over and over and over again.
Okay.
So all of the agents that are on here, make sure you go to the contract training. This is something that's super important. You should know the difference in what you can do and can't do with a ratified contract, and know that at any time anything changes, you have to be able to have that in writing agreed upon by all parties. Make sure you know that contract before you ever write your first contract, guys. We have plenty of training, we have it recorded, and you have your mentors as well. It's super, super important. You don't ever want to guide your clients in the wrong direction. There is no such thing as unheard of. There is no such thing as, oh, what is good, what is bad. It's all what's agreed upon. The contract is ratified and set in stone and walk away with the key. In order for it to be open and for you to have something else to add to it, everybody has to agree to that. It's almost like a puzzle where everyone has to have the pieces opened up together and everyone agrees to go in, right, and add it.
Yeah, I get that, but if, let's say the owner says, oh, no, I don't wanna do that, they still don't lose. the
Ratified
offer,
contract is
Still have
ratified.
that original deal.
But it's ratified. That ratified contract will continue on.
So
That ratified
so
contract.
they could put it on the table and negotiate, but still keep the original deal.
You have to, even not still, they have to, it's a ratified contract, they cannot get out of it, so that is, the contract is ratified, you keep talking about this, the buyer is obligated to fulfill that contract as is.
Well, the buyer wants to, they just wanna know, could they just switch?
Yes,
Yeah,
yes,
that's
that contract is still
This-
in
The
place.
contract is in
regardless.
place, yeah, the contract is in place and cannot be changed unless it's already agreed in writing.
Okay.
Yeah, it has to be, so it's super important you guys to know that. I'm gonna go ahead and let Susan go, because that is a mentor question. Susan, thank you so much for your time, I really appreciate it. And then, we will continue on with this. So make sure that you guys get with your mentors though on this, because this is something, I wanna make sure that everybody passes these contract, classes and is able to talk to their mentor. All of you guys should be going through the contracts with your mentor with a pass or fail ratio. If that has not happened, I definitely want to get with the mentors to make sure that that is going on with everybody, so that they know the difference in a ratified contract, what can and can't be done with the ratified contract, what can be changed, what can't be changed, how it can be changed, because it needs to go through.
Question, and I remember you were involved in this. I have a ratified contract, the seller made some changes, so they sent me the contract around 4 p.m. That was like 6 months ago. And the next day around 10 a.m., the agent says the contract is canceled because we did not have a ratified contract in less than 24 hours. Then I was.
We couldn't have a ratified contract and not have a ratified contract. So in the beginning, if I remember correctly, it really was not ratified. It wasn't signed and ratified, correct?
Yes.
Yeah, that's what, so once, if it's not signed and ratified, yes. Yes.
So she canceled it like
Yes.
10 hours later.
Yes.
And I said, you cannot do that.
You can.
And she said, yes, oh yes, I can.
That's
So-
correct.
Until it's
Until it's
100% ratified,
It's
it's
not
everything is an initial and signed off on. Until it's 100% ratified, any party can rescind their offer and decline to follow through with it. Because at that point, it's just an offer. It's either in an offer or a counter offer stage. So it sounds like yours was in a counter offer and the sellers changed their mind, probably because they received a better offer or whatever.
Yeah.
And so they rescinded their counter offer.
So my complaint was, that contract, for us to ratify, it was sent less than 24 hours ago. So we have, you should give us time.
They don't have
And she
to.
said,
Time
no.
is
Of
always
the essence.
always.
It's of the essence.
I tell it to my buyers all the time, like anybody that wants to sit and think on it, and I tell them, I was like, it is your right to sit and think on it. I don't want you making a decision without having my thought to it. Just understand at any given point, the seller can rescind their offer. I tell everybody that just so that they understand, if they don't move quickly, they could lose the opportunity. Not saying they should rush their decision, just saying they should understand all aspects of it.
I'm going to go with this, but we'll leave it. All the new agents, if you want to stay on at the end, we can talk because this is something that they already know. I want to answer your questions, Jim, but let's do the simplistics of it at the end so that the tenured agents can move on. And then if you all want to stay as newer agents, we can go through a few scenarios if that will help you guys for sure. But let's get through this and then we will let the tenured agents go and then we'll stay on with anything you guys want to talk about. But yeah, time's up. They can do it in an hour if they want to. They can do it 10 minutes if they want to. But we'll go through that here in a second. So one of the things that I wanted to say is happy birthdays to everybody. So, hold on, wrong page here. Let's do some happy birthdays. So Monica Klein, happy birthday. Caitlin Parker, happy birthday. Wendy and Michelle, happy birthday. Ryan and Brittany, happy birthday. And I believe, yep, that's the last one there. So we're gonna sing happy birthday. Happy birthday to you. Happy birthday to you. Happy birthday, dear Monica, Wendy, Ryan, Brittany, and Caitlin. Happy birthday to you. Woo! All right, and then the top agents, for some reason, I guess my post did not go up, but I did grab this to put up. There we go. So top listing agent by volume, Denise Kensko. I'm gonna repost these today so they went up because they didn't go on our Facebook. Transactions is Stacy Porter. Volume, Gail Driver. Transactions, Gail Driver. Top listing team by volume, Rockstar. And transactions, Rockstar. Top closing team by volume, the Burns Group, and transactions, the Burns Group, and commercial closing, Jeannie Rosalia. Woo! All right, guys, congratulations. I'm gonna repost this because I have them for some reason on our Facebook. All right, we lost about 10 people, so probably we were talking. We'll save those extra questions for the end, guys. When it's a new agent question, let's take it for the end. If we have Carla, are you still on here?
Yes, I am.
All right, you have the floor and then we'll let everyone go.
Okay. So everything's going pretty good. Everybody's doing all their paperwork and turning it in. Do want to remind everyone, since we are getting busier and getting more listings coming in, we only have 1 day from the date you put the listing to start to make it active in the MLS, 1 business day. So if everybody waits until Friday afternoon to turn in their listings, it makes it a little difficult on Caitlin to get them all in, you all to review them, upload the photos and the documents. So if you could turn it in 2 days in advance, minimum of 1, that would be amazing. Because we do want to give you all the time to review your listing and make sure that everything is accurate on our end and your end as well. Also, Rain does require 1 exterior photo of the home. If it's a condo, it needs to be of the building. If you do not provide that photo, they'll be happy to take a photo for you and charge you $50. So that's pretty much the only thing I have, just to bring to your attention that our time frame is really short as far as getting your listings in.
I have Holly who wants to tag in real quick.
Yeah, just as far as like the uploading your listing for all you new agents, please make sure your dates match. So the date on your purchase, on your listing agreement, and the dates on your data input sheet on when it's supposed to go live, all of those dates need to match, because if they don't, your document's gonna get rejected, you're gonna have to do a listing change, and that's just gonna delay your listing getting uploaded. So if you're gonna bring it down to the wire, at least make sure all your dates match.
Correct. Thank you, Ollie.
You're welcome. All right, so any of the new agents, if you want to stay on, we can sit here and mastermind for a little bit with some questions you may have about contacts. Everybody else, I hope you have a prosperous and wonderful day. I miss you all. I hope to see you in the office or over here at Gather. And even tenured agents, if you want to stay on, you're welcome to. But newer agents,